When it comes to legal contracts, words matter. Just ask my client Steve, who saved $40,000 in legal fees because of 20 words I put into his real estate contract. In this video, I'm breaking down the 5 essential legal clauses that every contract needs, including those magical 20 words that could save you tens of thousands of dollars. After watching this, you'll know exactly how to protect yourself and your business from costly legal battles. My name is Bashoy Habib, and I'm the realest real estate attorney you know. Over the past 12 years, I've closed 1,000+ transactions totaling $12 billion. I've negotiated, drafted, and reviewed thousands of contracts over the years, and today I'm sharing the 5 most important clauses you should include in all your contracts. Let's go. Let's start with my personal favorite, the non-disparagement clause. Think of it as a legal mute button for your haters. This clause prevents the other party from trashing you on Google reviews, social media, or anywhere else. Here's a quick story. Last year, my client had a contractor who wasn't happy with a payment dispute. Instead of handling it professionally, they went on a social media rampage. Because we had this clause in the contract, we got a court order forcing them to take everything down, and they had to pay my client $25,000 in damages. Without this clause, those negative reviews would have stayed up and destroyed my client's business. Next up, indemnification. Big word, simple concept. Here's what it means. If I mess up, I pay for it. If you mess up, you pay for it. Without this clause, you could be responsible for someone else's mistakes. A good indemnification clause does 3 crucial things. First, it clearly defines who's responsible for what. Second, it forces the responsible party to defend against any claims, meaning they have to pay for lawyers if someone sues. And third, it requires them to actually pay any damages or settlements that come from their actions. I always make sure my clients' contracts clearly state they're not responsible for what others do. The best indemnification clauses cover not just actual losses, but also potential claims, threats of lawsuits, and even government investigations. Think of it as a legal force field that keeps other people's problems from becoming your problems. Third is a well-drafted defaults and remedies section. This is where we get specific about what happens when things go wrong. You need 3 things here: what counts as a default, how long someone has to fix it, and what happens if they don't. Here's a pro tip that's made my clients a ton of money. Include something called a liquidated damages clause. Instead of trying to prove exact damages in court, you set a specific dollar amount up front. A perfect example of this would be when someone trashes your business online. How much is that review really worth? It's almost impossible to determine, right? So let's say you watched this video and added a non-disparagement clause in your contracts with a liquidated damages of $25,000 per occurrence. Then the other party subsequently breached. Well, now the parties have stipulated that $25,000 is a fair estimate of damages, and so the court will enforce that against the breaching party. And this is exactly what happened in the example I gave earlier in the video. I've seen people completely change their behavior when they see that $25,000 liquidated damages clause staring them in the face, because that's real. Fourth is dispute resolution. This is like choosing the battlefield before the war starts. So first of all, pick your jurisdiction, meaning where any lawsuit must be filed. I've seen too many clients stuck litigating in Delaware or Wyoming because they didn't read this part of their agreement. Also, make sure you understand if your contract requires mediation or arbitration before you can sue. Mediation is like having a professional negotiator work with both sides to find middle ground. They can't force you to accept anything, but they help guide you towards a solution that works for everyone. Arbitration, on the other hand, is basically a private court where an arbitrator acts as both the judge and the jury. Their decision is usually final and binding, meaning you cannot appeal even if you think they got it wrong. Fun fact, almost all residential Florida real estate contracts require mediation first, which means someone who owes you $5,000 might get away with it because it's not worth the hassle of mediation and then a lawsuit. That's why this matters. Finally, attorney's fee provisions. Most people think if they win in court, the other side automatically pays their legal fees. But that is actually not true. Without your contract expressly stating that you're entitled to recover legal fees, you could win your case but still lose tens of thousands in attorney's fees. That's why these magical 20 words are so important to include in all your legal agreements. In contract disputes, the prevailing party shall be entitled to recover attorney's fees and costs from the non-prevailing party. I've seen so many clients have to let the bad guy win simply because they couldn't afford to fight without this clause. These 5 clauses are like a legal insurance policy. Hopefully you never have to use them, but when things go wrong, and trust me, in 12 years of doing this, I've seen a lot go wrong, you'll be very happy that you had them in here. If you like this video and you want to learn more about protecting yourself in contracts, don't forget to like and subscribe for more videos every week. Thanks for watching, and I'll see you next time.